This public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the provisions of the Administrative Review Tribunal and other legislation Amendment Bill 2025. I begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. For people participating remotely, sorry, my thing's going to tell me I'm leaving in a second. I'm the Chair, Senator Jana Stewart. Joining me today via video conference is the Deputy Chair, Senator Claire Chandler, and we also have Senator Dorinda Cox. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground on which is claimed. If the committee determines to insist on an answer, the witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard in the recording of proceedings. Now, after that very long statement, I now welcome representatives from the Administrative Review Tribunal, and thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall give reasonable opportunity to refer questions asked of the officer to superior officers or a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanation of policies or factual questions about when and how policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear?
Good morning, Senators. Michael Hawkins, Chief Executive Officer and Principal Registrar of the Administrative Review Tribunal.
Sabet Haddad, Chief Lawyer, Administrative Review Tribunal.
Thank you very much. Would you like to make a brief opening statement before we go to questions?
No, Senators. Very happy to take your questions.
Excellent, excellent. We like to hear that. I will go first to the Deputy Chair, Senator Chandler.
Thank you very much, Chair, and thank you both for appearing in front of the committee today. Mr Hawkins, you were appointed as Registrar of the AAT, which is obviously the predecessor to the ART, and oversaw that transition. Is that correct?
That's correct.
Could I please clarify, would the provisions of this bill primarily apply to applicants currently in Australia?
Yes.
Why is this bill necessary?
I'll speak to the efficiencies that the bill will deliver the tribunal.
Great.
At present, we have a burgeoning student visa caseload in our migration jurisdictional area, and we also have growth in our protection area to the extent that those two jurisdictional areas alone speak to 90% of our entire caseload. So I'm driven, both during that transition period and today, to find whatever efficiencies we can to make us faster and fairer for our applicants before us. So this measure provides us flexibility. We have an increasing number of members in the tribunal and to join the tribunal. And to be able to do matters such as student visas on the papers enables us to have flexibility with where those members can work so we can encourage more flexibility in a work from home environment, so we're less reliant upon office and hearing room resource. It places a lesser emphasis on our public servants who are providing, setting up hearings. But interestingly, we also have large caseloads in other areas where matters might be set down for, say, 15 days and it settles on the proverbial courtroom door. So to be able to give that type of member a batch of these types of cases without having to give 2 weeks' notice of a hearing, without having to set up hearing rooms, creates an efficiency for us to enable us to get through this caseload more quickly.
So let's just drill down into those caseload numbers for a moment. My understanding is that the AAT caseload report for FY 2022 showed that as of 30 June 2022, which I note was just after the Coalition left office, the AAT had slightly less than 68,000 cases on hand. And the most recent published statistics for the ART at the end of the 2025 financial year show that the caseload's blown out to more than 111,000. What can you explain for the committee where that significant blowout comes from?
Yeah, Senator, primarily it is in the student visa caseload where, for example, in 2023, we had, less than 2,000 caseload 2,000 student visa cases a year, and now we're up around 38,000 a year.
I might have to ask the departments responsible for administering those visas why there's been such a huge jump, because that is a pretty significant number, isn't it?
It is, and we can't comment to that growth coming to us, obviously.
Yeah. My understanding is that the processing times, the time to finalise a case has significantly increased in the last few years as well. Is that right?
That's correct.
What's driving that significant increase in processing times? My understanding is it's gone from about 30 weeks to, more than double that, almost 68 weeks now.
I can say that in the past 2 years, we've had a focus on the aged protection caseload. We received special funding from the government to appoint a cohort of members to look at the very aged protection caseload. So as a consequence, our timeline is measured from the time of lodgement, obviously, to the time of finalisation. So because we've been doing that very aged caseload, some of those matters have been over 7 years, it has had the effect of blowing out, as you say, that timeliness of decision-making.
It's just a bit concerning, isn't it? Because the reason that the former Attorney-General Mark Dreyfus gave for abolishing the AAT and introducing the ART was that there were backlogs and delays in processing cases. But from the look of those numbers, it's worse under this new body.
If you look at the raw data, you might say that, Senator, but I think you need to drill down into it. And as I said, we have been dealing for the last 2 years with a very aged cohort in the protection cases. And if you look across many of our other caseloads, we are driving those numbers down in social services, for example, in veterans, in NDIS. We are seeing clearance rates in those high 80s, social services. We've got a clearance rate of 98%, I believe it is. 96% across the cohort, 80% in NDIS, finalised within 12 months. So it really is in these two jurisdictional areas that I've spoken of, being in migration and protection.
But you're sort of playing whack-a-mole, aren't you? Like, you get one type of case under control and then suddenly you get an explosion in another type of case.
Well, we can only finalise the matters for which we've got the resources, and at the moment we don't quite have the number of members to match the funding that we are resourced for. So we're confident that as new members are appointed, we'll be able to address these incoming cases obviously more quickly.
Has the protection caseload increased or decreased since 2022?
Since 2022. Since 2022, I've only got the 22-23 numbers, and active on hand were 40,137, and as at, these ones are August 31, we are 41,449.
Okay. Just to go to the student visa cohort, the bill, as we know, is primarily directed at the student visa cohort, and my understanding is that the AAT statistics show from June 2022 that there were 2,700 active visa student cases, and now it's 40,000. I might be looking. These might have been the numbers we were going through earlier, Mr. Hawkins. Is that right?
Yeah. So I can give you numbers for the 22-23 year. The active on hand were 2,278.
Yep.
And as at 31 August, now 42,110.
Yeah. So again, I'll have to ask the department to an extent what might be driving that increase, given they set the policy parameters around that. And how many? Sorry,
another question you might ask the department too is what their projections are for the following 12 months, which we understand will be similar to what we've had in the previous 12 months.
Yeah, my next question was how many are being lodged each year with the ART?
Okay, so lodgements in 22-23 it was 2,057. In 23-24 it was 11,668. Mm-hmm. That peak commenced in about April of 2023. And in 24-25 it was 32,198. And from 1 July to 31 August, 5,755.
Wow. So one can assume you're well on track to exceed that 32,000 for this financial, as in this upcoming financial year. If you've already got 5K or 5,000 odd, I should say, in the last little while. How many cases are you resourced for each year, and how many do you resolve each year?
Okay, so for 24-25, we were resourced to finalise 39,800 matters in what I call our business as usual funding. And then we were resourced to resolve another 12,000 of those backlog matters that I spoke of before, the aged caseload, for which we did have the appropriate number of members appointed.
Okay, and so how many of those cases were you able to resolve?
We did, you'll see in our annual report, which I believe will be tabled very shortly, I think it was 46,000.
Okay.
And my narrative on that, Senator, is the fact that whilst we were financially and funded for the number of finalisations, we didn't have the appropriate number of members actually appointed to resolve that targeted number of 52,000.
Right. What was the reason behind that?
That's a matter for government and the appointments of the members.
Right. Could you tell me, Mr. Hawkins, what proportion of student visa holders make protection claims that eventually come to the ART? Sorry, I can't say that acronym. ART.
On current protection matters we have before us, it would appear that it's about 20% of protection matters before us originated as student visa applicants. Okay. So yes, moving forward, I am mindful of a potential for there to be a number of these lodgements that we have now convert to protection visas.
Mm-hmm. And so is there any concern around applicants who might otherwise be within the scope of these changes applying for protection visas and being able to circumvent the the concept of having a hearing on the papers?
I shouldn't think so. It wouldn't be any different to what currently exists.
Okay.
Do you have a view on that? No.
So this is probably a little bit hypothetical, but if I were a person who was motivated to try and stay in Australia, but I'd had my student visa refused, what is to stop me attempting to, creatively utilise the system by lodging a protection application, knowing that my matter wouldn't then be resolved for almost 3.5 years because that's the processing time, and then I'd be able to take it to the courts?
I wouldn't think there'd be any difference to the current practice, Senator.
Okay. Just a couple of technical questions about the bill. So part 1, which deals with cases other than the student visa cases we've just been discussing, says that the ART, I got it that time, can determine a matter without an oral hearing if it can be adequately determined in the absence of the parties. What objective criteria will the ART apply to conclude a matter can be adequately determined in the absence of the parties?
Sabet Haddad, Chief Lawyer. Well, Senator, that just depends upon the particular circumstances of the case. There's not specific objective criteria set. That formulation of issues for determination can be adequately determined in the absence of parties is already in other powers within Section 106 of the Act, which allows decisions on the papers.
So will you issue any guidance to codify exactly what that looks like? What that test looks like?
I can't speak for the President, Senator, but I think because it's very much determined upon the particular circumstances of the case, and you have to remember that these provisions apply across the entirety of the caseload, save for the student visa refusals if that progresses. The circumstances are varied and wide.
Sorry, we just had some people joining the committee hearing. Could a decision to determine an application on the papers itself be the subject of review, either judicial or merits review?
Yes, Senator.
Yeah.
Okay.
Except for the student visa matters, which will be mandatory.
Sorry, Senator Chandler, I'm going to need to share the call.
I have one more question, Chair, if I could just get to that.
Yeah,
thank you very much. Part 1 of the bill also says that a matter can proceed without, I'm going to have to check my quote here, without guidance, and will be issued or a criteria used to determine whether it has been reasonable in the circumstances to proceed without a hearing and whether there has been reasonable opportunity to make submissions about why a hearing should be held. So could this power be used in permanent visa and protection applications?
Yes, Senator.
Okay, thank you. Thank you very much, Chair. That's all from me for now.
Thank you, Senator. Senator Cox.
Thank you very much for joining us this morning, and I hope that you can hear me at your end. Yes, great. Thank you. Thank you for just outlining quickly some operational issues in relation to or challenges which need to be addressed through this bill. If the bill doesn't actually pass, can you just elaborate for me on what some of those operational challenges or consequences might be for the tribunal? And, what can the committee expect to see and the community more broadly should this bill not be passed?
So, Senator, it's a very good question. As I've said, what I'm driven by are efficiencies for the tribunal. I do believe that this bill, in enabling student visas, of which constitute, I think, 37% of our caseload, to be able to be handled on the papers, is an efficiency from both the flexibility that we can have within our membership and the flexibility we can have within our accommodation. Now, if they weren't to pass, then I would say we will remain correspondingly inefficient in that way. We will obviously have accommodation pressures. and we'll be continuing to keep people occupied in setting up hearings, having to give 2 weeks' notice of hearings, having applications for adjournment of hearings. It's an efficiency that is attractive to the tribunal.
Right. So, the backlog that you've just spoken to Senator Chandler about, we could see that essentially just continue to, implode, for a better word, and to continue to create years and years of waiting, essentially, if we don't pass this bill. Can I go to our Attorney General, in her second reading speech, noted that the bill's recommendations were part of the Nixon review, and specifically around recommendation 32, which argued that the tribunal should be constrained from considering new information on merits review except in exceptional circumstances, which is in fact not included in this bill. But I can see the logic in not allowing new information to avoid sort of non-genuine applicants from exploiting or gaming the system. In this context, can you explain from a tribunal point of view your experience with respect to student visas or other temporary visa cohorts? And is this in fact a problem that needs to be addressed?
I think in this case, Senator, we are actually enabling applicants to put their best foot forward. So in the invitation that we'll be sending to applicants, we would be asking them to effectively make their case and to indicate if they haven't provided something in the past, it's now an opportunity for them to provide it. If they were prevented from being granted the visa at the department level, what is it now that enables it to be given to them? So there's going to be an opportunity for them to really put their best foot forward in writing, which the member will then be able to consider when considering the matter.
So if the bill were amended to constrain new information being considered by the decision maker, could you foresee any unintended consequences in that change?
Well, if the tribunal were constrained in taking into account new information, well, the criteria for student visas require the matter to be determined at the time, or the issues to be determined at the time of decision. So up-to-date information is important.
Sorry, there was a bit of a lag in the system there, so I don't know what happened at my end. It just stopped completely and froze. I just want to confirm, Mr. Hawkins, your experience therefore it's not operationally necessary to constrain new information. Is that correct?
No. I mean, we are actually inviting applicants to put their case.
Okay, I just wanted to clarify that point. So sorry.
So, Senator, this amendment varies considerably to what we had in the old IAAA, which was abolished as part of the reform, where in that situation, applicants were not enabled to present new material. So in this case, we're asking applicants to provide whatever information they can to assist their case.
Great, thank you. Thank you for clarifying that. I got the end of some figures that you were giving to Senator Chandler in relation to the percentage of student visa applications. Is that basically that are represented either by a legal professional or a migration agent? Were they over the last 12 months? And can you just clarify those for the committee?
A number off the top of my head was about 75% were represented.
So, Senator, I can clarify. I think since the tribunal's, the ART's inception, for student visa refusals, it's 27% of applicants who don't have a declared representative. And when I say declared representative, there may be assistance in the background, but they haven't nominated them expressly as part of the process. So yes, very, very close to 75% representation.
Great, thank you. And can you tell the committee what support services does the Tribunal offer to applicants for whom English is their second language?
Senator, all applicants to the Tribunal, including student visa refusal applicants, can avail themselves of the telephone and interpreting service provided by the Department of Home Affairs. And they can do that to contact us to have correspondence we send to them interpreted. That service isn't available for them to use to provide us with submissions. I will clarify that. But in any other communications with us, they can use that service.
So that's really just to query if they've got any questions about their case, or
if they've got any questions, if they, as I said, if they want correspondence that we've sent to them read out to them, the assistance of an interpreter, they can do that as well.
And does that also include, tribunal processes and, at what stage they're at or what the process is?
An explanation?
Yes.
Yeah, if they're telephoning, I mean, that's in no difference, I guess, if they were asking the tribunal, if they were calling the tribunal in English and asking what happens next, they can provide that. We also have fact sheets on our website in a number of languages.
Great.
If they want to talk directly with an officer, they can do that.
Excellent. That's all the questions from me, Chair. I'm happy to hand the call back.
Thank you, Senator Cox. And we also have Senator David Shoebridge on the line and Senator McLaughlin as well. I'm now going to pass the call to Senator Shoebridge.
Thanks, Chair, and thanks to the ART for attending. You were giving some numbers earlier about the number of filings in the ART, and there's been a surge of filings from particularly 24-25, and you're experiencing that surge again in the first part of this financial year. Can you give a breakdown on the number of those filings that are, I think you may have given the numbers earlier, but I didn't take them down, the numbers that are student visa applications?
Yeah, again, Senator. I'm happy to repeat those for you. 2022-23, we had 2,057 lodgements in student visas. In 23-24, we had
11,000 something?
668.
Out of how many? 2,057 was student. Out of how many?
Yeah, sorry. 22-23 was 2,057.
Yeah.
In 23-24, 11,668. In 24-25, 32,198. And from 1 July to 31 August, 5,755.
All right. And can you now give the total number of filings that you've had in the years?
Sorry?
So these were student
Yes.
lodgements. What is that as, you said they represent about 75% of all filings. So do you have all filings?
No, about 37% of total filings of the tribunal.
All right. So just to be clear, the numbers you just gave me, were they total filings or were they ones in relation to student visas?
Ones in relation to student visas only.
So what were the total filings in each year?
All right. Across the tribunal.
Yes.
Sorry, I don't have the historical data. I've got use of it.
So they're the lodgements.
All ART.
All ART. So that's
Okay, so 22-23.
Yeah.
All lodgements, Senator, 41,055.
Yep.
In 23-24, 50,238. In 24-25, 83,627. And from 1 July to 31 August, 13,345.
Okay, so has the proportion of student visas remained consistent at 37%? Those numbers seem to suggest that it was about 37% in 24-25, but historically that's not the case, much lower.
Yeah, look, at 24-25, it's about 37%. In 23-24, is that the number?
22.
It was 22%.
Yeah.
And in 22-23, it was 4.6%.
Yeah. And the and a number of submissions point out that you've had a relative surge in student visa applications. Have you spoken with the department for getting an explanation for that so as you can plan your resources?
We haven't had an explanation as to why. I've been interested more in the projection of lodgements.
All right. And what's their projection going forward?
They expect the current rate to continue or to increase for the next financial year.
All right. And have they explained to you why?
No.
And a number of submissions point out that approximately 50% of the student visa reviews, the decision of the department is overturned and it's remitted for decision. Is that right?
Sorry, Senator, I am having trouble hearing you, but yes, if your question is how many of those department decisions are set aside, it is.
Yes.
It is 50%.
Can you do that? Can you do that year by year?
Yeah.
Can you give me that year?
Hang on. Have you got the percentages?
I've got the percentages for student visa refusals.
Yeah.
Yep. So for 22-23, the number of set-asides was 43%. For 23-24, the number of set-asides was 46%. For 24-25, it was 47%. And for the first 2 months of this year, it's 46%. So those figures were different pre-COVID.
What were they pre-COVID?
They were closer to the 25%.
All right. So of the cohort of decisions that are being reviewed, almost half of them are being set aside, and that's double the rate pre-COVID. Now, you're not responsible for the workload that comes to you, but if you're having to set aside almost half of the decisions in a particular stream, you're correcting in many ways an earlier mistake in the system, aren't you?
Not so much a mistake, Senator. Sometimes more information is available to us when it gets to us. So it may be a year or two down the track.
What proportion have fresh evidence? Do you know?
We don't keep statistical data on that, Senator.
But there's something wrong in the system. There's clearly something wrong in the system which you're not responsible for when almost half of the matters that are coming to you in a particular visa stream are being set aside. You're not responsible for that, but it's an indication of something, some issue within the department, isn't it?
As I said, Senator, it can be availability of information at the time of decision.
It could be, is that? But you've got your finger on the pulse, Registrar. Is that what the members are telling you?
Well, certainly with COEs.
It can change. It also depends upon the length of which a case has been sitting with us. There can be a change in circumstances over a couple of years.
But
it can go both ways.
Yeah. Has there been any substantive analysis of that, about what is explaining such an extraordinary high set-aside rate?
I'm not aware of any substantive analysis, Senator.
We're focusing on getting the decisions out, Senator, sorry.
Is there any other part of the tribunal's work where you've got a significant caseload where you're getting almost half of the matters set aside?
Look, I think traditionally in the partner caseload, we have a high set-aside rate, usually higher than that. I mean, I'd have to check those figures.
Could you do me rather than try and press you for figures here, could you on notice provide the data going back, if you possibly could, to pre-COVID rates? And I know that's a bit of an ask, but it might give us a sense of if COVID has changed things. For refusal rates in the significant decision-making streams of the tribunal. By significant, if you're doing more than 100 matters or so.
Yep.
If it's easier just to produce all of them, by all means do that. But I don't put an unreasonable burden on you.
Just as I look at it now, with the information that I've got to hand, Our family and partner visas have a 52% change in decision. Study visas, as we said, 46%. National disability is 70%, but most of those are done by consent. But they're the ones that stand out, Senator.
Yeah, there was a trial, wasn't there, in NDIS of having matters determined on the papers. There was a funded trial. I think National Legal Aid referenced that. Are you aware of that?
No, when was it?
I believe that was that 2 years ago, Senator?
And
sorry, I'm not aware of that, Senator.
no, that's okay.
But we have a 96% settlement rate by consent in NDIS. It's a very small percentage that actually get to a member.
Well, the National Legal Aid says that there was a trial of having NDIS matters done on the papers with legal representation, and the trial said that dealing with NDIS matters on the papers was not successful. Now, you don't know about that, Registrar, but your Chief Legal Officer does. Can you talk to that?
Well, the trial wasn't run by us, Senator, so we have limited visibility over that.
Were you given the reporting on the trial?
I'm not aware of the reporting.
It wasn't done by us, it was done by an independent expert review program within NDIS, wasn't it? Yeah, within NDI.
Well, so was the outcomes of the review?
I'll see if I can get some information for you on that, Senator.
Well, if you could, if you were provided with the outcomes of the review of a significant trial where matters were determined only on the papers, it would obviously be of use in your consideration of this criteria. But nobody looked at that or sought some further information about that trial from that you're aware of in the ART registrar?
Not that I'm aware of, Senator, no.
Would be kind of potentially relevant, wouldn't it? If you've done a very recent trial in the last 2 years of having matters determined on the papers and it said don't do it.
It does depend on the case. It does depend on the caseload, yeah. Senator, and how procedural it is.
Well,
and we're saying student visas are quite procedural.
But just from my own perspective, it is a bit disappointing that the Tribunal is aware of a recent review of matters that have been determined only on the papers, which was critical of that and said it should not proceed, and then that hasn't informed your decision making here. Do you have any response to that?
No, other than we will have a look at that, Senator, and offer some advice.
Could you, if you have a copy of the review, could you provide it to the committee or any of the outcomes for the review?
We'll have to check. I don't know if we do have a copy of the outcomes, but I would simply affirm what Mr. Hawkins has said, is that the NDIS caseload is very different from the student or even the broader migration caseload.
Is there we've spoken largely about student visas being determined on the papers, which seems to be, is that your understanding, the primary focus of this legislation, Registrar?
Yes, it is.
Yep. There is, I think, is there a regulation making power to extend it to other visa classes?
I understand, yes.
That's correct, Senator. It can be extended to other temporary visas.
Other temporary visas?
I understand that protection and permanent visas are specifically excluded.
That's correct, by definition.
Yeah.
But otherwise, apart from permanent visas and protection visas, there's a regulation making power to extend this to other visa classes. Has the government had any discussions with you about what visa classes they are considering for the purpose of that regulation?
None, Senator, no.
Did you ask?
I'm familiar with the Nixon review, which suggested that visitor visas might be considered, but no, we haven't had a discussion about that at all within the Tribunal or with the department. And
visitor visas would be, would also include, say, bringing your parents out for a wedding, any temporary visa like that. Is that right?
I expect so.
Yeah.
But as I said, we haven't given any consideration to any other visa type than student visas.
Now, In terms of translation services, there's no translation service for documents that's free translation service available. Is that right?
That's correct, Senator. As I said before, it is possible for applicants, if they're talking to the tribunal, to use the TIS service to translate correspondence that we send them. As a matter of course, our experience in this cohort is it doesn't happen very often. People do use the TIS service across the tribunal generally to communicate with our own officers.
But that's to interpret material you've sent to them. It's
That's
not
correct.
to interpret matters so as they can put them before the tribunal for their cases.
Correct.
But the tribunal does provide an interpretation service for an oral hearing. Is that right?
We do if it's requested.
Well, obviously, you would only do it if requested. Do you know how many of the oral hearing matters involving student visas that interpretation services have been requested?
I don't have that data, Senator. I'd have to see if we can interrogate our systems.
Yeah.
But obviously, there's an access to justice issue here, isn't there? If there's no interpretation, if there is no interpretation service available for documents, but there is an interpretation service available for hearings, that could potentially be very valuable, particularly for some applicants who haven't really the resources or the capacity to interpret, to have translated their initial materials. The oral hearing might be the first time that they can actually have their material, their position translated clearly to the tribunal.
It's true, Senator, that they don't have, we do not provide a service that will translate their documents for us if they have those documents, and that would be submissions, because generally speaking, all other documents would be in English given the nature of the student visa requirements. They're in a position essentially as they would be when applying for the visa itself, which is to present the material in writing to the department.
But a student, many of these are renewal visas. Do you know what proportion are applications for renewal? So a student who's already onshore seeking.
So we only have jurisdiction over onshore student visa applications. So generally people have applied here. And if they're renewal, I will say that for most student visa applicants, there is an English language proficiency requirement.
And are you saying that that would include being able to, that proficiency requirement is of a standard where you can present your matter in a tribunal?
I'm not saying
that isn't my understanding of the proficiency standard for a student visa. I could be wrong. Are you saying it is?
No, I'm not saying it. And proficiency standards depending upon the course, where you're from, the course provider.
Correct. But they're not normally matched against your ability to persuasively present your case.
That is not the purpose of the criteria.
Correct. We're having a discussion about oral hearings. So what's the current numbers for oral hearings in student visa matters?
I don't have that data. I believe that...
Probably in the order of 70%, Senator, because about 30% are withdrawn.
It's probably fewer than that, because there was last year of the substantive decisions, and they're ones that don't include withdrawals or dismissals, 28% of student visa refusals were decided on the papers.
All right. And was that...
Sorry, just confirming, Senator Shoebridge, last question before I'll need to move on.
Well, could you provide us on notice a breakdown of student visa applications, again, going back if you can to pre-COVID, about which clearly identifies the proportion that have had a hearing, the proportion that have been determined on the papers, and then if there are criteria that the tribunal has available to us that explains why things have been determined on the papers or in oral hearing, if you could break it down by that as well. But can I just, my final question then, can you provide that on notice?
Yes, Senator, we could.
What's the duration of a standard oral hearing? How long do they take?
Sorry, Senator, could you repeat that question?
How long does an oral hearing in a student visa matter?
It depends. It varies between, well, obviously there's always going to be outliers, but the average is between 30 minutes and an hour.
Okay.
Thank you, Senator Shoebridge. Senator Cox has confirmed she's got one final question before we move on to our next witnesses. So, Senator Cox, and then we will be going to our next witnesses.
Yeah, thank you, Chair. I just wanted to place on the record that the ART is supportive of the proposals being put forward in this bill. Is that correct?
Certainly supportive of the efficiencies they deliver, Senator.
Thank you. Also, was the ART consulted with or involved in any of the policy development or the drafting of this bill?
Yes, Senator, we were consulted on the drafting of the bill.
Thank you very much, and thank you both for your evidence today. I'll hand it back to the Chair.
Thank you, Senator Cox, and thank you to our witnesses for taking the time to give evidence today. You've been asked to provide information on notice. Could you please forward it to the Secretary by the 22nd of October, and you'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request corrections to transcription errors. Thank you so much for your time.
Thank you, Senators. Thank you for the opportunity.
Thanks so much. I now welcome representatives from the Attorney-General's Department and the Department of Home Affairs. Thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officers to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear?
Thank you, Chair. We might start here in this room. We're joining from 4 different locations, so I might direct traffic a little bit to try and keep things organised. So Tara Inverarity, First Assistant Secretary of the Courts, Tribunals and Commercial Division. I'll go to my colleague in the room and then we might go Mr Still, Mr Kiley, then Mr Noble.
Matthew Traeger, Acting Director of the Administrative Review Tribunal Policy Section.
Okay.
Stephen Still, Assistant Secretary, Administrative Law Branch, Attorney General's Department.
Andrew Kiley, First Assistant Secretary, Migration, Citizenship and Humanitarian Policy Division in the Department of Home Affairs.
Matthew Noble, Assistant Secretary, Temporary Visas Branch, Department of Home Affairs.
Right. I think that's everyone that we've got there. Would either of the departments like to make an opening statement?
Thank you, Chair. No opening statement from the Attorney General's Department, and I'll ask Mr Kiley.
And similarly, no opening statement from us either. Thanks, Chair.
Thank you very much. We'll proceed to questions and I'll go to the Deputy Chair, Senator Chandler.
Thank you very much, Chair, and thank you to the officials for appearing today. I want to start by applauding the government for reintroducing what is essentially the Immigration Assessment Authority fast-track process for the student visa process. As we heard from the ART, there's obviously been a huge backlog in reviewing these student visa cases, so it's good to see something done about that. When did the government realise that it needed to reintroduce a process like the Immigration Assessment Authority?
Thank you, Deputy Chair. I might start first and then ask Mr Still if there's further comments that he would like to make. First thing I think we would say from an Attorney General's Department perspective is that we probably don't agree with the characterisation that the on the papers review process put forward in this bill is equivalent to the fast track process that the former Immigration Assessment Authority undertook. The IAA undertook a limited form of merits review, and needed to make its decision based on existing information and could only seek additional information that was not before the primary decision maker in very limited circumstances. So by contrast, the on the papers proposal put forward in this bill does not contain those limitations. It would still give applicants a full and meaningful opportunity to put forward their case. That case would just need to be put forward in writing. They will be able to make full written submissions and provide whatever evidence they wish to provide to the tribunal, and there wouldn't be any limitation on the new information that they could provide in support of their case. I might ask Mr. Still if there's anything else he'd like to add, and then allow colleagues from Home Affairs to also jump in if they wish.
I think I would merely add in relation to the timing of consideration of decisions on the papers. This is a matter that the department's been working on since late last year, but particularly since approximately June this year in relation to this bill.
Mr. Kylie, is there anything you wanted to add? Sorry. I am going to try and direct traffic just a little bit so we can make sure.
No, that helps me too.
Comments.
No, thank you, Ms. Inverarity. Nothing further to add to that description. Thanks.
Thank you.
So sorry, Mr. Still, you said that you were starting to look at the issue late last year, but in terms of hardening up the policy, it was June this year that work took place?
So, Senator, we've been giving general consideration to the concept of the Tribunal's decision on the papers powers for some time, as I noted, but we have been specifically working on this bill since the end of caretaker in approximately that June timeframe, yes.
Interesting. Were you aware that the Coalition had a public election commitment to restoring the fast-track review process for specified visa classes?
I think we were aware of that, Senator.
Interesting. Will members of the public have the ability to obtain written submissions and otherwise access the materials that the Tribunal takes into account in its hearings on the papers?
I'll ask Mr. Still if he knows the answer to that question. It could be also a matter that the Tribunal itself might need to comment on, but Mr. Still?
The answer is yes, Senator. The applicants, as they would for provisions that aren't within this process, have the ability to request, I believe from the department, the information that has been provided to the Tribunal in relation to the matter, with certain limited exemptions. But in essence, that's a carryover of policy that would relate to matters that are not to be heard on the papers.
I'm just trying to understand how we balance out this, general rule of underpinning the ART that its hearings and its proceedings must be conducted in public. But if you're undertaking a hearing on the papers, how do you apply that rule to ensure that the decision is public domain?
Senator, I think one of the features that would maintain public visibility of these matters is that the Tribunal has the discretion to select matters for publication. Although actually I think I might need to potentially take that on notice as to specifically how the publication rules apply in this circumstance, unless Mr. Traeger is able to comment. No. Look, I think we might take that on notice, Senator, to make sure we just give you a technically accurate answer.
Sure, and I'm specifically interested in understanding whether members of the public can obtain the submissions relevant to cases that are reviewed on the papers. So I think you just said that applicants can obtain documents, but can members of the public obtain them?
Yes, under 367, section 367, new section 367J, the applicant may request the department to provide access to any written information given or produced to the ART by the department for the purposes of the review. That provision does not deal with members of the public. And in relation to that question, I think it would perhaps be best to take it on notice to make sure we give you an accurate answer.
So you can't tell me today whether members of the public are going to have access to the documents that, I guess it's not a hearing, it's a decision on the papers, but you can't tell me whether those documents will be able to be accessed by members of the public in the way that ordinary hearings considered by the ART would be.
So to ensure that we give you an accurate answer, I think we'll need to take that on notice.
Okay. And again, I do want to be very certain that in taking that on notice that we're looking at the ability of members of the public to access the documents, not applicants.
Yeah, yeah, we've understood that. Thank you. We will make sure we respond to that on notice.
Just looking to this issue around the backlog, and I don't like using the word exploitation, but how that backlog could maliciously be utilised, I suppose, for want of a better expression. One of the core findings of the Nixon review was that the protracted processing times motivated abuse of the visa system. Do you accept that conclusion?
Sorry, would you mind just giving that extract again?
So the Nixon review found that because it was taking so long to process review cases, that could effectively motivate abuse of the visa system. And I'm wondering whether you agree with that conclusion.
Yeah, Mr. Kiley?
I might jump in here, Senator.
Thank you.
So, yeah, very aware of the Nixon review and the commentary that she made in relation to protracted processing times. I think the department generally agrees with that assessment that protracted processing times provide opportunities for further exploitation of the system. And this measure certainly does relate to trying to address that in some shape or form.
Mm-hmm. So would it be your view that this bill is essentially intended to deal with the problems that come from a massive visa caseload?
This bill is targeted at ensuring efficient and effective merits review processes in the student visa system, primarily.
Sorry, did someone else say something then? No, it might have been my connection. Why didn't the government also implement the other part of recommendation 32 of the Nixon review and apply this approach to tourism stream visas?
Mr. Still, did you want to say anything about that or cover the regulation making power?
Senator, the focus of the government in this bill has been specifically on the ability to hear matters on the papers. In relation to that second element of the Nixon recommendation, it's simply beyond the scope of this bill. I do think that there are a range of policy considerations that would need to be worked through if that were to be considered. I think you will have noted in the tribunal's evidence that it's possible that circumstances change which might result in a person either being entitled or in fact not entitled to this. So I think it's a matter that would require some careful thought for implementation.
But it's not a matter that the Attorney General's Department has yet turned its mind to in terms of addressing.
Right, final question, Senator Chandler.
I might leave it there if that's all right. Thank you, Chair. I think I've reached the end of that section. Thank you.
Thank you very much. Senator Cox.
Thank you, and thank you all for appearing today. Can I start with the Department of Home Affairs? My understanding of this bill is that it is informed by the Nixon review. So just on the back of Senator Chandler's questioning there, can the Department of Home Affairs just explain briefly to the committee the context of that review and why it was so important to focus on this area?
Thank you, Senator. So, as the committee would be aware, Christine Nixon was engaged in 2023 to undertake that review, which really looked at sort of exploitation across different elements of the visa system. She made a range of recommendations to the department, to government, to address various areas of exploitation. In relation to this particular bill, as has already been discussed, recommendation 32 and related recommendations went to ensuring the effective and efficient operation of the visa system, and as part of that, in particular, making sure that merits review, whilst continuing to be available, was conducted in an efficient and effective way. And as colleagues from the Attorney General's Department have already noted, that has informed the development of this bill in relation to the student visa caseload in particular.
So can the AGD then explain in just a bit more detail for the committee, for the purposes of this hearing, how, in fact, the bill implements the recommendations from that review?
Mr. Still?
Senator, so recommendation 32, as has been noted, indicated that certain visa classes ought to be determined mandatorily on the papers. The bill provides that there will be a mandatory, in the Migration Act, that there will be a mandatory requirement of hearings on the papers in relation to student visas and in relation to temporary reviewable migration decisions in relation to temporary visas that are determined by regulation, which potentially could apply to other visa classes. For the matters that are within scope, the bill introduces a new division in the Migration Act to specifically set a procedure for dealing with those matters. It provides that for those matters, there is no right, there will be no oral hearing, but it does provide a procedure to ensure that procedural fairness is afforded to the applicant. So under the bill, the tribunal is required to write to the applicant to invite them to put submissions on why the primary decision was not correct. So if they thought that the criterion that the visa was refused on was satisfied, why it was satisfied, or if the reason under the Act that the visa was refused, why that provision did not in fact apply. So there's a requirement for the tribunal to provide an opportunity for the applicant to provide submissions to the tribunal on the reasons, essentially on the reasons that their visa was initially refused. There's also a requirement which mirrors the existing requirement in the Migration Act for the tribunal to put the applicant on notice of new adverse information that's come to their possession that is adverse to the person's case. And so the applicant will have an opportunity to respond in writing to the issues that led to their visa initially being refused. Once the tribunal has that material from the applicant, they are then able to proceed to make a decision. That is, in essence, a hearing on the papers as recommended by Nixon Review, because it enables the person to understand the issues that have led to their visa being refused, put their submissions on that so that their side of the case is heard, and for the tribunal then to proceed to make a decision on the papers.
Thank you very much. I just want to go to the temporary visa cohort just quickly. And I've noted that the bill also provides regulation making power for their temporary visa classes to be added to this process. Are there any constraints on this power or the types of matters that can be included in that process?
Well, Senator, we've referred to two constraints that are kind of inherent in the design of the provisions. So one is that this division can only apply to reviewable migration decisions. That term is defined in a way that explicitly does not include protection visa decisions. And so one constraint is that because of the way that the power is framed, it cannot be extended to protection visas. The second constraint, which in a sense you've mentioned, is that the only temporary visa classes and no permanent visa classes could be specified. Those constraints are both in legislation. And then as to the matters that government might consider in what classes could be specified, that is of course a matter for government, but it would go to the suitability in terms of complexity of matters that relate to a particular visa class.
Thank you for clarifying that. And just picking up some of Senator Chandler's questioning in relation to the now abolished Immigration Assessment Authority, this process is different. And so I just wanted to clarify that the IAA mandated the on-papers review for protection matters, whereas this bill specifically excludes protection matters. Is that correct?
It's correct, Senator. The IAA related to protection matters. This bill would prevent decisions on the papers in relation, the bill is designed so that this decision on the papers procedure cannot apply to protection visa matters.
And I think it might be worth clarifying there that it's this mandatory on the papers process that's going into the Migration Act, which would not be able to be applied to protection visa decisions, distinct from the amendments that are being made to the ART Act, which provide a broader discretion, but not a mandatory process.
Great, thank you for clarifying that. I just also wanted to pick up on Senator Shoebridge's questioning of the previous witness in relation to the NDIS on papers pilot. Are you aware of that?
I'm sorry, I'm not, but Mr. Still, do you want to speak to that?
To my knowledge, we weren't specifically aware of that. And so I'm not sure that we're in a position to comment on it without taking a look at precisely what is being referred to.
But I'd just like to make some general comments, though. Like, I would assume that NDIS matters can be quite complex and, given the individual circumstances that are varied, particularly in relation to some of these cases, given the varied nature in which, the lived experience of Australians living with disability. So, there would at some point be the need for some closer oral examination. Would you agree with that statement?
I think what we would say there is that, as I just mentioned, the bill has two key components, one of which is amendments to the Migration Act, which only apply at this point to student visa decisions, noting Mr. Still's comments before about the regulation-making power, and then amendments to the Administrative Review Tribunal Act, which add to the circumstances in which the tribunal may make its own discretionary decision to proceed without holding an oral hearing, with some guidance about when that discretion can be exercised. As to whether any of the NDIS decisions that are before the tribunal would be matters in which the member might choose to exercise that discretion, I think is such a case-by-case matter that we couldn't answer at a level of generality. But Mr. Still, was there anything you wanted to add to that?
Without commenting on particular cohorts, I suppose what I would say is that the government's identified that this class of decisions is suitable for decisions on the papers because, generally speaking, it relies on relatively objective factors, is less complex, has relatively limited volumes of documentation. That's clearly, those factors are clearly not features that will apply to the whole of the tribunal's workload.
So can I just make an observation there, Mr. Steele, that the department therefore could distinguish those circumstances from which there's the student visa cohort, which generally requires that objective assessment. So, for example, it'd be relatively straightforward for the department to determine in writing if an applicant for a student visa was actually an enrolled student. Is that correct?
I think the department you're referring to there would be the Department of Home Affairs, so we might refer to them to speak to that.
Mr. Noble, are you able to address that one? Thanks.
Thanks, Senator. Yes, we would expect that student had a valid confirmation of enrolment for studies in Australia.
Thank you. That concludes my tranche of questions. I'll hand it back to the Chair. Thank you very much to you all.
Thank you. Senator Shoebridge.
Thanks, Chair, and thanks to both departments for turning up. Just quickly with the attorneys, there's a regulation making power to extend this to other classes of visa. Have you had any discussion or any directions yet that would indicate what visas that's intended to cover?
No, I think that the fact that the bill only covers student visas would indicate that that's the cohort that the government has identified at this point in time. I think it's fair to say if the government had identified other visa cases that should fall within this procedure, they would also be covered by the bill at the time. So the regulation making power provides for that to be undertaken in future, but there's nothing that we're looking at right now.
Well, the Nixon review indicated that this process should be extended to pretty much all temporary visas, I think excepting protection visas. You would be aware of that recommendation in the Nixon review?
Yeah, Mr. Still addressed that earlier in response to earlier questioning, yes.
And has there been any discussions in your department about that recommendation from the Nixon's review and this regulation making power?
Not that I'm aware of, but Mr. Still?
So we're evidently aware of the recommendation, but we have not in any detail turned our mind to those other visa classes.
I'm sorry, Mr. Stiller, I couldn't hear that. Could you repeat it?
So we are aware of the scope of that recommendation, but we have not considered any advice in relation to those other visa classes at this stage.
Was it because of that recommendation that you included the regulation making power?
So I think the government's view would be that if the purpose of the bill is to enable approach to decision making that's proportionate to a particular class of matters, in this case student visas, that that logic might apply to other visa classes. And given that it is appropriate to include a regulation making power if such a class is identified, but it's really a matter for government whether and when that power might be exercised.
All right. So do I understand, Mr. Steele, the reason that the decision was made to make this change so that the overwhelming majority of student visa applications are determined on the papers was because the scope or nature of that visa was appropriate?
Senator, certainly the government considers it appropriate that that procedure apply to that class of visas, those classes of visas.
Yeah, but you indicated it was because it was of a relatively modest nature, that if it was a more significant matter, then you'd obviously have an oral hearing. Or did I misunderstand you, Mr. Steele?
I think if I might jump in there, Mr. Steele, that the student visa category has been sort of chosen as appropriate to form part of this on the papers process in the Migration Act with a few considerations in mind, which includes the nature of the issues that will be under review, the temporary and short-term nature of the visa types, and the low volume and complexity of written materials relevant to proceedings of this kind. So those are the considerations that have been taken into account in applying there's others, but those are key to the decision for why student visas are in this, but also I think the substantial caseload is relevant to that determination as well.
Well, okay, I think I understand. One of the problems I have is the Ombudsman is against you on that. The Ombudsman in their submission says this, a student who is already in Australia and who is seeking the renewal of their visa is likely to have invested considerable time and resources in pursuing their education, and it would seem particularly unfair to deny a student in such a position the opportunity to have an oral hearing. There's a lot of power in what the Ombudsman says, isn't there, Ms. Imberity?
I don't necessarily agree that it is unfair to not provide the applicant with an oral hearing in these types of matters, because the on the papers process will still provide them with a full merits review process. It will just be conducted in writing.
Well, the Ombudsman also says that when it comes to determining matters on the papers, students, and again, I'll quote from the Ombudsman's submission, students are generally young and may be unlikely to persuasively argue their case in a written submission, given the complexity of the Migration Act, without professional assistance, which they may find prohibitively expensive. To a certain extent, this does apply to oral hearings. However, in those cases, a tribunal member is able to ask questions of a student if representing themselves. That's removed, isn't it, by going to a hearing on the papers, the ability of a tribunal member to ask questions for clarification or for additional material in a hearing. That's just removed when you go to a hearing on the papers, isn't it, Ms. Inberg?
Yes, that oral ability to ask questions would not be present, but procedural fairness still would be.
Well, yes, but one of the key points in an oral hearing is the tribunal member may have questions. There may be some gaps in a student's application, and those can be addressed in an oral hearing in a way that they can't be addressed in a hearing on the papers. I mean, I think that's a fairly obvious result of the changes, isn't it?
I think we are absolutely in agreement that there will not be an oral hearing as part of this process, and that means that engagement that would be part of an oral hearing would not be present. I think where we disagree is that necessarily equates to unfairness.
Well, a student may have spent an incredibly large amount of money and years of their life obtaining credentials in Australia, and this student visa application, this extension, may be essential for their being able to either complete those qualifications or engage in such further study as they could remain in Australia. This could have incredibly significant impacts on a person's life, couldn't it?
I think the question of whether or not they get the visa could have substantial impacts on their life. They will still be entitled to full and independent merits review through this process, with the full ability to put their case forward and
but not in an oral hearing. You're removing the right for an oral hearing.
That is the purpose of the amendments, yes.
Yeah. Have you had any analysis about the extent to which this will then lead to additional judicial review matters?
Mr. Still, I might defer to you on that one.
Senator, we are conscious that the administrative law system operates as a system between primary decision-making, merits review, and the judicial system. We have been very careful to design the provisions in a way that minimises the chance of an increase in judicial review rates from this cohort. What I would say is that it would be very difficult to specifically model individual behavioural choices that result from a policy change, but it is something
So you don't
that,
have
of course,
any...
the government will monitor closely.
You haven't done any assessment about what the impact this will be on the federal court?
I think it's very difficult to model the impact of the removal of the oral hearing on what that will mean for the case flow through to judicial review. So, as Mr. Steele mentioned, it's
particularly difficult if you don't try. It's particularly difficult if you don't try, and you haven't done that. I was asking if you've gone through the process. I wasn't asking about hows and whys and wheres. I was asking if you've gone through the process, and the answer is no. And we only have a short amount of time, Ms. Imbrera. Is the answer no?
If I could finish my remarks, what I was saying.
It's to the question, yes.
Well, given you've been speaking over me, perhaps you could repeat the question.
Have you gone through and modelled the impact this will have on the federal court?
And I think what Mr. Steele has just said is that we are aware of the potential for an impact, but modelling is very challenging. And therefore, if what you're seeking is there a document that is modelling, the answer is no.
All right. I might just go to Home Affairs. The proportion of decisions that have been remitted back for rehearing, because the tribunals form the view that the decision of the tribunal, has formed a very different view to what the department found, has increased from about 25% pre-COVID on student visas now up to almost half. Why is the department getting it wrong so often?
Thank you, Senator. I don't accept the premise of your question that the remittal rate suggests that the department is getting it wrong.
What indicate was it?
I don't agree with that, Senator. As you'd be aware, merits review is a new decision. It's made by the tribunal member on the basis of information that is provided to the tribunal member for him or her to make a decision on the merits of the case before them.
Why has the remittal doubled?
On a different fine.
Sorry, Senator, can I just...
We just have very little time
to answer your questions. You've got a couple of minutes, but please allow the officials to finish answering the questions.
Thank you, Chair. So it does not suggest in and of itself that errors were made at the primary stage. There's often a period of time between primary and merits decision making, which means that there is the potential for a change in circumstances that is taken into account by the merits review process. There may be new information that's available to the decision maker at merits review. We're certainly alive to the remittal rate. And as you'd probably be aware, the Ombudsman did a review into merits review last year and made a few recommendations, one of which was about the continuous improvement. We accepted that recommendation and continue to look at how we can learn from cases that are remitted to the department. But to the premise of your question, no, we do not agree that suggests that the department is getting it wrong. Mr. Noble can go into more information if needed, Senator, but I don't...
Have you looked at the explanation for why the referral rates after an ART hearing or AAT hearing has effectively doubled from 25% pre-COVID to now 46 and 47%? Have you looked at an explanation for why?
We have been looking to that. As I said, Senator, we've worked with the Ombudsman. We've accepted their recommendations. It goes to elements of the caseload. It goes to some of the integrity issues that we're seeing in the caseload post-COVID and the measures that the government has put in place to address that. But I'll ask Mr. Noble to provide a bit more detail on some of the elements that we're seeing in those remittals that are coming back to the department.
Thanks, Andrew. Thanks, Senator. Just to fill in a bit more information there. So as Mr. Kiley mentioned, we are working on getting better reporting from tribunal outcomes, and that links into that Ombudsman report recommendation. So we hope over time we've got more granular information to work with here. But common reasons for remittal in the student space, what we do see is a lot of objective material, accessible items such as confirmation of enrolments, penal clearances, English assessments, financial capacities, medicals, biometrics. If they've been refused on those objective grounds, when it gets to review and those documents are provided to the tribunal, we will often, of course, see a remittal on that objective evidence. We have a genuine student requirement as well, which is a component of our refusals. And obviously some of those remittals can also come down to a subjective assessment of the student's circumstances at time of review as opposed to at time of primary decision. And that can sometimes be many months in between.
Sorry, so the tribunal is in the tribunal process, the students are able to provide additional documents, which sometimes deals with some objective criteria. Is that one reason?
Correct.
You don't ask for that when you're going through the process. It seems to me to put this huge burden on the ART rather than having a process inside the department that asks for these questions. An unfair workload that you're giving to the ART.
No, again, I don't agree with that question, Senator. We will assess a student application against the criteria for that particular visa subclass. That will include an assessment of the objective criteria that Mr Noble went through. If that information is not provided to the department as part of the primary application, the certificate of enrolment as one example, then the visa application will be refused on the basis that that information is not provided. What we are seeing in this case,
rather than give an opportunity to say we're going to refuse it because you haven't provided these documents, would you like to provide the documents? You refuse it, then an application is needed to be filed in the ART at expense and delay. The ART's expenses are used, and then the documents are provided, and then it's remitted back to you. That's the current process. So you don't see that as inefficient?
I'll let Mr Noble talk to the process we go through to ensure that all information is available to decision makers. But one of the things that we are seeing with this caseload is individuals looking to, as has been discussed earlier in this hearing, exploit the system by not providing the material in the first instance to the department to prolong their stay through seeking merits review and providing the information at that later stage.
All right.
But I'll ask Mr Noble.
Mr Kiley, I will ask you, if you're making that assertion, to tell me what substantive basis you have for making that assertion and what proportion of matters you think are covered by that, and if you have any evidentiary basis to make that assertion, Mr Kiley.
I don't have the statistics available, Senator, but we do.
Are they available anywhere?
Anecdotally, that again, there are a range of integrity issues in this case, but I'll ask Mr Noble to provide more detail on how we look to ensure that we have the information available at the primary decision-making stage.
Thanks, Mr Kiley. Thanks, Senator. The department does a range of quite significant outreach across our global network, including industry, education agents, etc., to ensure that where possible, we get decision-ready applications with all that objective criteria provided up front. We try and run a very efficient process here in the student program to ensure, obviously, genuine students can come and commence their enrolment. So I'd make that point first, that we expend a lot of time around that engagement. Also, our systems are geared towards decision-ready applications. Now, where there's an objective item, such as a confirmation of enrolment or medicals or biometrics, we have a process in place that we call a request for further information, and we will follow up in most instances with that client to provide an opportunity for that to come through before we make a decision. That's quite common practice. If we're to move to a decision without some of that objective criteria, it can often at refusal stage be coupled with other concerns, poor immigration history, visa overstay, etc.
So, to be clear, you say some of the reasons for this high return rate from the ART are being addressed through the Ombudsman review and the Ombudsman process. Is that part of your evidence?
The department's always focused on effective decision-making. We work constructively with the Ombudsman.
My question was about the Ombudsman's review, though. Is that going to address some of the refusal rates? If you could just address that, then this hearing can end and my life can move on, as can yours.
Thank you, Senator. As I was saying, we are focused on effective decision making. We engage constructively with the Ombudsman in the preparation of that particular report. We've accepted all the recommendations and we're going through the process of implementing those.
My question was, are you intending that to have an impact on the return rates from the ART? That's
we
my
will look
question.
to ensure through implementing recommendation 3 that we have effective decision-making processes in place. I will not comment on whether that will necessarily impact the remittal rate, given my response to your first question, which is we don't accept that.
It's all good. It's all fine. After that's been said, nothing to see here.
That's not what I'm asserting, Senator. What I'm saying is that a remittal in and of itself does not suggest an incorrect decision was made.
Well, I would suggest to you it's bloody well indicative of it, but we'll have to just agree to disagree on that.
Thank you, Senator Shoebridge. We'll leave that there. I want to thank officials from the Attorney General's Department and the Home Affairs Department for appearing to give evidence today. If you've been asked to provide any additional information, will you please forward it to the Secretary by the 22nd of October 2025? And as is usual, you'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request corrections to any transcription errors. And that concludes today's proceedings. And thanks again to all witnesses who gave evidence to the committee today. Big thanks to Broadcasting and to the Secretariat for all of their work in supporting today's hearing, and I declare the hearing adjourned.